Hello, my name is Karen Smith and I am an examiner of titles at Erin based in our Waterford office. Today I am delivering to you lecture 2 on the topic of applications for first registration based on documentary title. So when I say applications based on documentary title, this means where you have title deeds as distinguished from applications for first registration based on possession. So here we are dealing with forms 1, 2 and 3. You'll all be aware that compulsory first registration is triggered in the situations that are set out on the slide. The one that will concern you most will generally be a conveyance, lease or assignment on sale. So once you've completed a conveyance, lease or assignment on sale involving an unregistered title, you must then apply for first registration of the title. There are two different options here. One route is an application requiring an investigation of title, which is a Form 1 or Form 2 application, and the other is an application based on certification, which is a Form 3. I'll start today with Forms 1 and 2. I will briefly take you through the forms in a practical way, and hopefully this will enhance your understanding of the content of the checklists that you'll have to consider when you're submitting your application. It is important to appreciate that whilst a lot of the issues being raised may seem basic, that a huge percentage of applications are actually rejected for basic issues. I'll also address boundaries and mapping and classes of title as we go through the lecture today. So starting with Form 1 and Form 2 applications. They're very similar in their makeup, in the averments that are contained within each affidavit, and in the supporting documents that you'll require. The main difference is that if the title you are applying to register is a freehold title, the applicant swears the affidavit in Form 1 of the Land Registration Rules, whereas if the title you are applying to register is a leasehold title, the applicant swears an affidavit in Form 2 of the Land Registration Rules. Form 5 and Form 6 are of course applications for first registration based on possession, and these are dealt with in a separate lecture. So the present process in Tailteann Éireann is that applications will initially undergo a map and application check, and if there are any issues on the application then will be returned highlighting the first issue arising. Now whilst only one error is highlighted in the rejection, there may be more than one error, so the applicant should consult the checklist before relodging the application and ensure all requirements have been met. If the map and documents are in order and the application passes the map and application check, then the application will be read in full by a deciding officer. Rulings may issue at this point and the application may be returned with rulings. If there are no rulings or no notices required, then the application may proceed towards completion. Now, it will have to be noted that Tailteann Éireann is not an advisory body and can't provide any guidance on specific applications, so lodging parties are advised to consult the Land Registration Rules, the practice directions, the legal office notices, and the registration mapping guidelines, all of which are available on the Tailteann website. So it's important to note that this whole process will not result in any loss of priority, as the date of registration and first registration applications is the date of settling. So when a deciding officer reads your application and decides that everything is in order, then the new folio will be drafted and settled on that date. That is the date of registration and not the application date, as with registered land. And whilst I'm on this point, can I just please add that because the date of settling is the relevant date, if there is any change in respect of the property, such as a new mortgage or if the property is sold, and when I say sold, I mean that a deed has been executed, not that the property is sale agreed or in contract, then this will have to be reflected in the application. The new owners must submit a Form 1 or 2, as the property will have to be registered to the person in possession of it. So moving on to the actual application now. Now I've used Form 1 as the main example here, but most of what I have to say is common to both application types. I'll point out any Form 2 specific issues as I go through the form. The first question to ask yourself when you begin is whether or not the application is suitable for Form 3. If it is suitable for Form 3, then you should consider at this point whether you wish to use the more simplified procedure in Form 3. I will of course be going through the Form 3 procedure later in the lecture. So the opening of the form then, you'll need to consider who's going to swear the affidavit. If it's an individual, the applicant swears. If there's more than one owner, then all the applicants must swear. If it's a company, then the company secretary swears it. In limited circumstances, the company director may swear it, but you must add averments to the affidavit that director is duly authorised and has the necessary means of knowledge to swear the affidavit. So that wording isn't contained in the actual precedent prescribed form. So if you do want to have your affidavit sworn by a director, you have to specifically insert the extra averments to the effect that the director is duly authorised and has the necessary means of knowledge to swear the affidavit. Now, please note that a solicitor shouldn't swear an affidavit. Affidavits sworn by solicitors will generally be rejected. It will be only in very limited circumstances, such as if the solicitor is a law agent for a county council, for example, that this would be appropriate. So please ensure that the affidavit is sworn and not declared. The averments in the form must be on oath. I'd also like to draw your attention to the date of the affidavit. Lodging parties should ensure that the affidavit is dated within a year of lodgement. If an application has been returned a number of times, it may be the case that the date becomes an issue for later relodgements, and this should be checked. Please ensure that the jurat is completed correctly. It should either read, "and I know the deponent," and all the other wording is deleted, or it must be signed by the solicitor who is certifying that they know the deponent. Next, paragraph 1, which corresponds with part 1 of the schedule. So please ensure that the description of the property is correct and that you refer to the application map, which should be attached to your form. If you're using a deed map as your application map, then please specify this. Just ensure that the deed actually contains a map. Attach a copy of the map to your Form 1 or 2 and then specify that the original is in the specified deed. Please check the land registry maps before you lodge the applications. Quite often, some or all of the land being applied for can already be registered. And in that scenario, if land is already registered, then it simply cannot be part of an application for first registration. And if the applicant has an issue with boundaries, then this will have to be resolved directly with the registered owner of the lands. You will need composite maps if the property is held under different titles. The different lots must be shown on a map and identified with different lettering or colouring. So when it comes to identifying your property that's being applied for, there are a number of different scenarios which can apply. You should consider whether your property complies with one of the identification scenarios. Here are some examples and some questions you might ask yourself. So, do the boundaries of the property follow ordnance survey details? And is the property accurately described in the deeds in accordance with an identifiable address? If the address is number 44 John Street, Waterford, that should be identifiable. However, if the address in the deeds is a townland only, then this will generally not be sufficient to identify your property. Is there a good map with proper OS detail? You may or may not be aware that a lot of the older deed maps do not have sufficient OS detail, ordnance survey detail, on them to enable our mapping officers to properly identify the property. And what you need is a good map with proper ordnance survey detail on a deed, which is a good route of title. So a good map on a recent deed will not be sufficient. It must be a good route of title. If you do have this and the property does follow ordnance survey detail, then the property should be identifiable. If you have a map on a deed which is a good route of title, but the map is not sufficient for our mapping officers to identify the property, then a declaration of identity from an architect or other suitably qualified person may be required, and then they would certify that the land as outlined on the application map is all or part of that on the map on the deed, which is a good route. If there aren't any maps on part title, if the address is not sufficient for identity, if the boundary doesn't follow OS detail, then we will probably need the names and addresses of adjoining owners and occupiers so that we can serve notice on them. Multi-storey buildings, or MSBs, relate to apartment units or office buildings at multi-floor levels where the building has not been registered in its entirety. MSB applications should have a land registry compliant map and relevant floor plans lodged that correspond with the description of the property in the deed. MSB applications differ really only in relation to our mapping requirements and how the property is described in Part 1A of the new folio. The latest mapping guidelines may be referred to for a more detailed explanation of MSB mapping processes. MSB registrations are identified on the map with an MSB marker. So an MSB building is shown as in this screenshot. You can see that the image from Land Direct here shows a blue box. This is the MSB marker, and it indicates that there is an MSB development and an MSB tree has been created to register different departments and retail office units in that building. If your application is an MSB application, there are different additional mapping requirements, and the PD on mapping practice is a useful reference. Still on paragraph 1 then, but on the second part of paragraph 1, which corresponds with part 2 of the schedule. So if there are no burdens for registration, use the latter wording in the brackets at the end of the paragraph and then state none in part 2. So just to emphasise that you must adhere to the prescribed wording in this paragraph. You may choose the first phrase or the second phrase, but you should not amend the prescribed wording. And part 2 should not be deleted. If there are no burdens, just leave in part 2 and state none. Bear in mind that only section 69 burdens should be included here and not section 72 burdens. And a reminder that rights of way and easements expressly granted prior to first registration will affect without registration and shouldn't be included here. Same will go for leases with a term less than 21 years. They're not section 69 burdens. If you have listed a lease here which does have a term greater than 21 years, or if you have a mortgage in part 2, then those deeds must obviously be lodged. In relation to a mortgage then, we will want the original deed. If it relates to more than one property and the original deed has already been lodged with a different application, then this should be stated, and then always lodge a solicitor's certified copy of the deed for this application. We cannot take up other instruments and make copies of deeds for the current application and explain where the original, so you must lodge essentially your solicitor's certified copy of the deed for the current application and then explain where the originals are and why the originals haven't been lodged by you. And also in relation to mortgages, just remember that we're dealing with unregistered land, and if you do lodge a Form 52 stated to be supplemented to a deed of mortgage or a debenture, then it's generally best practice to lodge the original deed with the application. If the mortgagee is not one of the main Irish financial institutions, then you may need to lodge company information for that company. Also, a reminder that for Irish companies, we will require at least a solicitor's certified copy of the certificate of incorporation. Same for a foreign company, and also depending then on whether or not they have a branch in Ireland, the relevant company office certificates. Moving on to paragraph 3 of the affidavit, which corresponds with part 3 of the schedule. This is where you'll be including the statement of title. So first of all, ask yourself which rule you're applying under. If it's Rule 19.1, you'll need a good root of title which is older than 15 years. If it is under Rule 19.2, you'll need a good root of title which is older than 12 years. But you will then also require evidence that the current market value of the property is less than €1 million. Now, this could be evidenced by an auctioneer's current valuation or the deed from a very recent sale for value. So 19.1, 15 years, and 19.2, 12 years, but the value of the property must be less than €1 million. Please draft a proper statement of title showing the effect each deed is alleged to have had on the title. So for example, I've shown on the slide a specimen to statement of title. This isn't just a schedule of documents or a list of deeds lodged. What you need to do is identify the most recent deed, which is a good root of title. Start with this. Do not lodge prior title unless it is necessary. So for example, if you have a fee from grant, or if you have a situation where the property has been described throughout the title in accordance with a map on a prior title deed, then that deed should be lodged for mapping purposes only. And similar to the composite map I mentioned earlier, if there is more than one title, then please set them out separately in your statement of title. So on the statement of title, for example, the freehold title has been set out and the leasehold title has been set out separately. And then this particular statement of title sets out how the leasehold has merged into the freehold interest. Next then we have paragraph 4, which is the inhibition section. And if an inhibition is not required, then just delete this paragraph. If an inhibition is required, then please ensure that you include the full correct name and current address for service of notices. Moving on there then to paragraph 5. So there's not to my knowledge, and then also paragraph 6 states I am not aware. Now, please do not change this to there's not the company's knowledge or the company is not aware. The company doesn't have the knowledge. The company secretary is making the affidavit. They have the knowledge and they're making the affidavit from their own knowledge. The affidavit must reflect this. Everything must be disclosed, and this point brings me on to searches and what searches must be lodged with your application. So you must lodge judgment office searches against the applicant and any person on title for the last 5 years. If the applicant is a company, you should lodge company office searches. Registry of deed searches are required against all those on title from the root of title up to date. And here's a quick reminder of the searches that we require. So from the date before the deed to the date after the registration at the registry of deeds of the subsequent deed. Now, of course, if the deed is not registered at the registry of deeds, then the searches should be right up to the current date, as there are no subsequent registry of deeds registrations. You should lodge the original searches, please, and just check your searches that you're lodging to make sure that the explanations of the acts appearing make sense in the context of your application. So if an act is explained as being on title, but it's not actually part of the title lodged, then that explanation won't be correct. Or if an explanation states see letter of undertaking, again, that might make sense in the context of the searches when you're closing your sale, but it doesn't make sense to us, and you should really update all your explanations to suit your application, sign and certify the explanation of the acts. Moving on to paragraph 7 then. I did touch on this briefly earlier, but I just wanted to emphasise the point again in relation to original deeds. So you must lodge all original deeds or explain why you have not lodged the original deeds and lodge solicitor certified copies of the deeds. If the original has been lost or destroyed, then this really should be disclosed and you should lodge a lost deed affidavit, including an indemnity from the applicant, a solicitor certified copy of the deed, or an official copy registry of deeds memorial of the deed. That's not available. So basically you're dealing with a documentary title, but all or some of the deeds are missing. Then you have to make proper efforts to search for the missing deeds. So we'll be looking for you to show any correspondence which you've sent out to try and locate the deeds and any replies that you got back. You'll then be trying to reconstruct the title as best you can, whether with official copy memorials from the registry of deeds, whether with certified copies of the deeds, plain copies accompanied by official copy memorials, the best evidence that you can establish. And if you're purchasing a property on the spaces where there are lost deeds, please be sure to get a lost deed affidavit from the vendor and all the documentation which you will need for a first registration application, which the applicant will then refer to in their own affidavit. In paragraph 8, the words "and no proceedings are pending in any court relating to the said property" are omitted on a very regular basis. I'm sure it's because the phrase is right in the middle of wording in italics and it tends to be deleted along with the wording in italics, but it's a very important phrase and we will ask you for a fresh affidavit if that phrase is omitted. The final paragraph in the affidavit then is paragraph 9, where you're setting out exactly what you're applying for. So generally with the Form 1, you'll be applying for an absolute freehold. I'll come back to that point in a minute. If there's more than one applicant, here please set out if they're joint tenants or if tenants in common, and if they're tenants in common, in what shares. And if the applicant is the company secretary should state here, "I apply on behalf of the company." On this slide, though, I have set out the classes of title which can be registered. As I've just said, generally with the Form 1, you'll be applying for an absolute freehold. If you're applying in Form 2, you'll generally be applying for a good leasehold. If you are applying for an absolute leasehold, then you must prove the lessor's title, the freehold, and any intermediate interest in order to be granted absolute. The same proofs are required if you're applying in Form 1. So lodging a plain copy of an old deed will not suffice for this. If you haven't provided the right documentation for an absolute leasehold, then you'll be registered with a good leasehold title. Qualified title then is where there's a specific qualification placed on the title, which can vary on a case-by-case basis. And a possessor title probably not very common, as it's not really very marketable, and it's really only suitable for limited circumstances. So whilst on the topic of leaseholds, I just want to do a quick reminder about the terms of a lease in the different contexts. So if the lease term is less than 21 years, then it cannot be registered as a burden or obtain a new leasehold folio. If the lease has a term greater than 21 years, then it must be registered as a burden, regardless of how many years of the term are left to run. So if you're lodging an application today and the property is subject to a lease which has 5 years left to run, if the original term of that lease was greater than 21 years, then it must be registered as a burden. However, if we were applying for a new leasehold folio and there are only 5 years left to run, then we cannot open a new leasehold folio for that, as the lease must have a residue in excess of 21 years for a new leasehold folio. Next slide refers to execution of deeds under a power of attorney. So this used to be seen mostly in relation to individuals, but now we see it a lot in relation to companies. For individuals, we want the power of attorney and the solicitor's legal statement. For a company, we will want the same, and then depending on how the power of attorney has been set up, we may need evidence regarding the holding of a role of an office. For an enduring power of attorney, then we need the court office copy of power, solicitor's legal statement, and evidence that the donor is no longer able to manage their affairs. The next slide draws your attention to a number of issues in relation to releases. So please check the execution of any releases you are lodging. If it is executed under a power of attorney, we'll need the power of attorney documentation. If it's executed by a foreign company, we may need the foreign legal practitioner certificate. If the release is executed by a party which is not the original mortgagee, we may need to see how they are entitled to the interest in the mortgage, which then allows them to execute the release. If the execution is on a page attached to a deed, we may need confirmation that it was affixed prior to execution. We usually require the original mortgage deed and the original deed of release. They're the title deeds. They should be handed over on closing. And remember that we are dealing with unregistered land, and a request to withdraw a mortgage is not appropriate. It will either need to be registered or you'll have to lodge evidence that it has been released. So moving on now to the Form 3 application for first registration. So what exactly is a Form 3? Form 3 is a modified first registration procedure pursuant to Rule 19.3 and Rule 19.4 of the Land Registration Rules 2012. So in these cases, the solicitor investigates the title and certifies it. And to our Form 3 is accepted title to heir and does not investigate the title. That's how Form 3 application differs to other first registration applications. With a Form 1, a Form 2 or a Form 5, our legal services unit will carry out an investigation of title and then make a registration based on that investigation. Whereas with the Form 3, solicitor investigates the title, certifies it, and it's on solicitor certification that we are relying when making the registration. There is an updated practice direction on Form 3s which clearly sets out our requirements in relation to Form 3s, making it an extremely useful resource for solicitors. Rule 19.3 is the standard form of Form 3 application. Rule 19.4 relates specifically to registration of statutory authorities. For Rule 19.3 applications, the deed under which the applicant acquired their interest must be for valuable consideration. Consideration in the deed mustn't exceed €1 million, and the deed must be dated within 5 years of lodgement of the application. For Rule 19.4 in relation to statutory authorities, it's not quite as strict. The deed is not required to be sale. If there is consideration, it must not exceed €1 million, and there is no time limit in relation to the date of the deed at the time of lodgement of the application. So you should consider using a Form 3 where you do have a recent conveyance, lease or assignment on sale dated within the last 5 years, where the consideration does not exceed €1 million, and where you can vouch for the title. Form 3 may not be appropriate where your most recent deed is a voluntary conveyance or assignment or a deed of assent, where your prior title or part of it is based on possession, where there's full purchase monies have not been paid over prior to the application, where the original deed under which the applicant acquires their interest cannot be lodged, where the solicitor certifying the title is a party to the transaction, where the interest acquired is an enlargement of an existing interest of the applicant in the property, where the applicant is not in possession, so for example if they've sold on the property, or where a step in the prior title is impossible or erroneous. This is what the current version of Form 3 certificate looks like. The certificate must be in this prescribed form and it must contain each of the 8 prescribed paragraphs. We have editable PDF and Word versions of the prescribed form available to you in the form section of our website, and make sure you're using the most up-to-date version of the Form 3. So a number of points just in relation to the form itself. For freehold applications, the Form 3 certificate must certify the fee simple in paragraph 3 and the title applied for in paragraph 8. The original deed of conveyance and sale must be lodged, and it's this deed which must be referenced at paragraph 2, and then any section 69 burdens. For leasehold interest, the Form 3 certificate must again be in the prescribed format. The lease details should be set out in paragraph 3, and the title applied for at paragraph 8. The original deed to the applicant should be lodged, and any section 69 burdens should be disclosed on the certificate, including those identified during the course of the investigation of the title. The certificate must be signed by the individual certifying solicitor, and it must be dated within 1 month of lodgement. The solicitor certifying the title in the Form 3 certificate must be the solicitor who acted for the purchaser in the conveyancing transaction. Sometimes we'll see applications where X has certified the title in Form 3, but then the deed Y has actually witnessed the execution of the deed by the purchaser in her capacity as a solicitor, but then that raises a question for us as to whether X actually acted for the purchaser in the conveyancing transaction. The vast majority of the time there is a perfectly valid explanation for this, but it's something you should just be aware of. This type of situation will result in a query, which you could preempt by providing an explanation when you lodge your application. So what documents are required in support of your Form 3 application? Your Form 17, as with any application you lodge to Erin, will require a fully completed Form 17 signed by an individual solicitor and dated. Your fees, which currently stand at €130. There's no fee payable for a mortgage lodged with first registration, and there is no fee for the opening of a new folio. But if you do require a copy folio file plan to issue on completion, you will need to provide us with the additional €40 and include it in your Form 17. The original deed under which the applicant acquired their interest must be lodged, and if you're not in a position to provide us with the original deed, the Form 3 procedure would not be deemed appropriate. Any other deeds affecting the title must be lodged, such as a mortgage or prior title deeds evidencing Section 69 burdens, for example. So fee farm grant, a deed containing covenants, or a lease for a term exceeding 21 years to which the interest acquired is subject. Just a few further points in relation to the leasehold application. So for a leasehold application, we'll either have a leasehold where the deed of lease is lodged and the original lessee is the applicant, or a leasehold where the original deed of assignment is lodged and the assignee is the applicant based on the original lease. And assent to the registration of the lease as a burden may be required if the immediate superior interest comprises registered property. So that's Section 69.1 and Section 69.2 of the Registration of Title Act 1964. If this is the case, then a query would be raised for Form 48 to be lodged before the application could proceed any further, as the lease burden must be registered under Section 69 of the Act. So again, if your superior interest is registered property, you'll need an assent to register the lease as a burden. If the lease is a sublease, then ideally this should be stated. And also please note that if the head lease is registered as a burden on the freehold folio, then we will register any sublease as a subleasehold interest. If the title applied for is an absolute leasehold interest, as I've already mentioned, the solicitor must confirm that they have satisfied themselves to the title to the freehold and any intermediate interest, and that as a result of their investigation of these titles that are satisfied that the leasehold folio obtained is absolute. Otherwise, you can confirm that the title should be good leasehold. The certificate can be provided in the Form 3 or in the cover letter with your application, and this will avoid a query having to be raised at a later date. In relation to a lease of registered land, sometimes it transpires that the property applied for is already registered, and this cannot proceed then as a Form 3. It should be relodged as a lease of registered land, post May 2006, together with the relevant fee. You must lodge your land registry compliance map also outlining your subject lands. If the original conveyance or assignment refers to a map attached to an earlier deed, a solicitor certified copy of that deed should be lodged, including a colour copy of the map. As already mentioned then, any other deeds affecting the title must be lodged, such as the mortgage or prior title deeds evidencing Section 69 burdens. So in relation to your lodgement of prior title, title doesn't investigate the title in these cases, so therefore your general rule of thumb when it comes to prior title deeds or documents is that they should not be lodged as part of your application. However, just to repeat quickly some of the specific exceptions to this set out in the PD. So where the interest acquired is a leasehold interest, you must lodge either the original lease or a solicitor certified copy. In a freehold where there's a fee farm grant on title, you must lodge the fee farm grant or a solicitor certified copy. Where the current deed describes the property in accordance with a map attached to an earlier deed for identification purposes, you must lodge a solicitor certified copy of the deed with a colour copy of the map attached. And where in the course of your investigation of title you've identified some Section 69 burdens in the prior title deeds, you'll be disclosing these here in the Form 3 certificate, and then you're required to lodge the original or solicitor certified copy of the deed in order to effect registration of the burden. And just a little note there that you are not required to lodge searches with the Form 3 application. There are, of course, a number of further information sources which I have referenced here on this slide and which may be useful for you to refer to. So thank you very much for your time, and best of luck.